Report of the Center-State Relations Inquiry Committee, 1971, by Rajamannar, Government of Tamil Nadu, read by Ramani. Chapter 21, Summary of Recommendations. Our recommendations are set out below. Administrative Relations, Issue of Directions to the States by the Union, Articles 256 and 257 and 339(2) should be omitted. Alternatively, it may be provided that no direction under any of those articles should be issued except in consultation with and with the approval of the Interstate Council. Article 344(6). This article should be omitted. Interstate Council. The Interstate Council should be constituted immediately. It should consist of all the chief ministers or their nominees with equal representation for all the states, and the Prime Minister should be its chairman. No other union minister should be on the council. Every bill of national importance or which is likely to affect the interests of one or more states should, before its introduction in Parliament, be referred to the Interstate Council, and its views thereon should be submitted to Parliament at the time of the introduction of the bill. No decision of national importance or which may affect one or more states should be taken by the Union Government except after consultation with the Interstate Council. Exception may be made in regard to subjects like defense and foreign relations. The recommendations of the Interstate Council should ordinarily be binding on the center and the states. If for any reason any such recommendation is rejected by the central government, such recommendation, together with reasons for its rejection, should be laid before Parliament and the state legislatures. Legislative field. General. A high-power commission should be constituted for a redistribution of the entries of lists 1 and 3 in the 7th schedule to the Constitution. This committee's recommendations regarding the 3 lists are as follows. List 1, Union List, Entry 7. This entry should be made more precise by confining it to armament industries proper. Entry 32, Article 285, exempting Union property from the imposition of tax by the states should be repealed. Entry 14, lotteries organized by the states should be omitted from this entry and included in the state list. When including this item in the state list, it should be specifically provided that the states will have the power of prohibiting or regulating any activity in connection with or relating to a lottery organized by the government of another state. Entry 48, futures markets should be transferred to the state list. Entry 52, this should be restricted to industries of national importance or of an all India character, or to industries involving a capital of more than 100 crores of rupees. Entries 53, 54 and 55, these 3 entries should be transferred to the state list. Entry 67, this entry should be transferred to the state list. Entry 76, the audit of the accounts of the states should be transferred to the state list. Entry 84, the power to levy excise duties on medicinal and toilet preparations containing alcohol, etc., should be transferred to the state list. List 2, state list. Entry 23, this should be modified to include oil fields also. Entry 51, this should be altered so as to empower the states to levy excise duties on medicinal and toilet preparations containing alcohol, etc. New entry. A new entry should be inserted providing for the making of laws relating to inquiries and statistics for the purposes of any of the matters in the state list. List 3, concurrent list, entries 5, 8, 17, 19, 22, 23, 24, 25, 28, 30, 31, 32, 33, 34, 35, 36, 37, 38, 39, 40, and 42. These entries in their entirety should be transferred to the state list. Entry 45. The reference to state list should be omitted. Consultation with states before legislation by Parliament. Before any bill is introduced in Parliament in relation to any entry of the concurrent list, the Interstate Council and the states should be consulted. At the time of introduction of the bill, the remarks of the Interstate Council and a brief resume of the opinions, if any, of the state governments should be placed before Parliament. Residuary powers. The residuary power of legislation and taxation should be vested in the state legislatures. Other legislative provisions. Article 154 2b and 258 2. No law should be made by Parliament conferring powers or functions or imposing duties upon a state or its officers or authorities without the consent of the state. Article 169(1). The power to abolish or create legislative councils should be vested exclusively in the state legislative assemblies without the necessity of any parliamentary legislation. Article 249. This article should be omitted. Article 252. The state legislatures should have the power to amend or repeal an act passed by Parliament under this article. Reservation of state bills for consideration by President. All provisions regarding the reservation of state bills for the consideration and assent of the President, except the provision in Article 288(2), should be omitted. Promulgation of ordinances by Governor. Need for previous instructions from the President. The proviso to Article 213(1) should be so modified as to restrict it to cases falling under Article 288(2). Financial relations. Corporation tax, customs including export duties and tax on the capital value of assets. The base of devolution of revenues on the state should be widened by including A. Corporation tax, B. Customs and export duties, and C. Tax on the capital value of assets in the divisible pool to be shared by the center and the states. Excise duties. All excise duties and cesses, special, regulatory, or otherwise, which are shareable at the option of the Union, should all be made compulsorily divisible between the Union and the states. Additional duties of excise should be continued only with the concurrence of the states. Even if the additional duties of excise are abolished and they are replaced by the levy of sales tax by the states, the restrictions now imposed on the levy of sales tax by sections 14 and 15 of the Central Sales Tax Act 1956, Central Act 74 of 1956, as regards the rate of levy and the stage of levy, should be totally repealed. The power of Parliament under Clause 3 of Article 286 should not be exercised except in consultation with the states. Taxes levied and collected by the Union but assigned to the states under Article 269. Every one of these taxes should be levied by the center, though the collection may be left to the states. Surcharge on income tax. The surcharge should be merged with the basic rate of income tax so that it can be shared with the states. In future, no surcharge should be levied except with the consent of a substantial majority of the states. Restrictions on the power of the states to levy tax on the consumption or sale of electricity. Article 287 should be omitted. Grants. Grants by the center to the states, both for plan expenditure and non plan expenditure, should be made only on the recommendation of an independent and impartial body like the Finance Commission or similar statutory body. Finance Commission, it should be expressly provided in the Constitution that the recommendations of the Finance Commission shall be binding on all the parties, center as well as the states. The Finance Commission should be a permanent body with its own secretariat. A member of the Planning Commission may be appointed as a member of the Finance Commission. Loans and indebtedness of states. A committee of experts may be set up to consider the entire issue relating to the indebtedness of states. The committee to be set up may also consider the desirability of constituting an authority analogous to the Australian Loan Council or forming a development bank on the lines of the World Bank to deal with applications made to the center by the states for loans. Relief fund. There should be a fund for each state for the relief of distress arising out of natural calamities. The fund may also be utilized for ameliorative measures. Planning Commission. The Planning Commission should be placed on an independent footing without being subject to control by the Union Executive or to political influences. To secure this objective, it should be placed on a statutory basis by Parliament, enacting a law providing for the establishment of a Planning Commission. The Planning Commission, to be established by law, should consist of only experts in economic, scientific, technical, and agricultural matters and specialists in other categories of national activity. No member of the Government of India should be on it. The law should be made in this behalf, should deal with the tenure, term of office, and conditions of service of the members of the Planning Commission, which should have a secretariat of its own. The existing Planning Commission should be abolished. The duty of the Planning Commission should be to tender advice on schemes formulated by the states. It will also have the responsibility of making recommendations for consideration by the Finance Commission regarding grant of foreign exchange to states for industrial undertakings started by or in the states. Each state may have a planning board of its own. Planning and Development. The Industries Development and Regulation Act 1951, Central Act 65 of 1951 should be repealed and replaced by an act providing for the control by the Union of such industries only as are of national importance or of all India character or which have a capital of more than 100 crores of rupees. The provisions relating to grant of licenses should be completely omitted. The state should have the power to grant licenses to start new industrial undertakings within the state, either in the private sector or in the cooperative sector. The state should also have the power to start and carry on industrial undertakings in the public sector, except in fields reserved for the Union, with or without foreign collaboration. Where foreign exchange is needed for any industrial undertaking, licensed or started by a state, it should be provided by means of block grants to be allowed to each state on the recommendation of the Finance Commission made in consultation with the Planning Commission, the judiciary, the Supreme Court. No appeal from the High Court should lie to the Supreme Court in ordinary civil, criminal, or other matters, whatever the pecuniary interests involved and whatever the sentence imposed, except in a case involving constitutional issues or the interpretation of a central act. In appointing judges of the Supreme Court, it is desirable to secure, as far as possible and without detriment to efficiency, representation for the high courts and the bar of the different parts of the country. High courts, the power to present an address to the President for the removal of a judge of a high court from office, should be vested in the state legislature itself, subject to the substantive and procedural safeguards now embodied in the relevant provisions of the Constitution and the Judges' Inquiry Act 1968, Central Act 51 of 1968. The power regarding the salaries and allowances, leave and pensions of High Court judges should be vested in the state legislatures, subject to fixation in the Constitution itself of minimum salaries. Article 222 should be omitted. Article 223, 224, and 224A, these three articles should be so amended as to expressly provide that the President will act always in consultation with the Governor, who will have to be guided by the advice of his Council of Ministers. Whenever any particular provision of a state act is challenged before a high court, on the ground that the provision is unconstitutional, the state government concerned should have the power to move the High Court for referring the question to a full bench of 3 or more judges, of whom one should be the Chief Justice. The bench so constituted should consider each and every provision of the Act concerned, and once its decision is rendered, no provision of the Act should be challenged thereafter on the ground of unconstitutionality. The Governor should be empowered to refer any question of law or a fact of public importance to the High Court for its advisory opinion. The Governor should be appointed always in consultation with the State Cabinet. The other alternative will be to make the appointment in consultation with a high-powered body specially constituted for the purpose. The Governor should be rendered ineligible for a second term of office as Governor or any other office under government. He should not be liable to removal except for proved misbehavior or incapacity after inquiry by the Supreme Court. A specific provision should be inserted in the Constitution enabling the President to issue instruments of instructions to the governors. The instruments of instructions should lay down guidelines indicating the matters in respect of which the governor should consult the central government or in relation to which the central government could issue directions to him. Those instructions should also specify the principles with reference to which the governor should act as the head of the state, including the occasions for the exercise of discretionary powers. The provision in the Constitution laying down that the ministry holds office during the pleasure of the governor should be omitted. In particular, the instruments of instructions should be provided as follows. A. The governor should appoint as chief minister the leader of the party commanding an absolute majority in the Legislative Assembly. B. Where the governor is not satisfied that any one party has an absolute majority in the Assembly, He should, of his own motion, summon the assembly for electing a person to be the chief minister, and the person so elected should be appointed by the governor as the chief minister. C. The advice of the chief minister to the governor to dismiss any minister should be accepted by the governor. D. Where it appears to the governor at any time that the chief minister has lost the confidence of the majority of the members of the assembly, the governor should immediately and of his own motion summon the assembly and direct the chief minister to secure a vote of confidence in the house. E. If the chief minister fails to seek the vote of confidence, or having sought it fails to get the necessary vote, the governor should dismiss the chief minister and the council of ministers headed by him. It should be made clear that Article 103(1) confers power on the governor to exercise discretion only in relation to matters in respect of which the Constitution makes express provision. For example, Articles 239(2), 371(2), 371(a), 1 and 2. Emergency provisions. Emergency confined to a state. Articles 356 and 357, the provisions may be totally omitted. In the alternative, sufficient safeguards should be provided in the Constitution itself to secure the interests of the states against the arbitrary and unilateral action of the ruling party at the center. If the provisions are to remain, 1. The only contingency which may justify the imposition of President's rule under Article 356 is the complete breakdown of law and order in a state, when the state government itself is unable or unwilling to maintain the safety and security of the people and property in the state. 2. The words "or otherwise" occurring in Clause 1 of Article 356 should be omitted, and 3. A proviso should be added to Article 356(1), requiring the President, before issuing the proclamation, to refer the report of the governor to the Legislative Assembly of the concerned state for expressing its views thereon within such period as may be specified in the reference. Article 365, this article should be omitted. National emergency, Articles 352, 354, etc. These drastic provisions, such as those relating to financial allocation, should not be put into operation unless there is war or aggression by a foreign power. The expression "internal disturbance" occurring in Article 352 should be interpreted to mean that it must be comparable in gravity to the repelling of external aggression. Article 353(a). No direction under the article should be issued except after consulting and with the approval of the Interstate Council. In cases of emergency, directions may be issued under the article, but the Interstate Council should be consulted at the earliest possible opportunity and further action taken in accordance with the recommendations of the Council. Financial emergency, Article 360. This article should be omitted. Public services, All India services, recruitment to the All India services should be either by transfer of members of the existing gazetted services under the control of the states, or by direct recruitment, or by a combination of both these methods, if need be, by holding an examination confined to each state under the supervision of the Union Public Service Commission, if deemed necessary or expedient. Article 312 should be so amended as to omit the provision for the creation of any new All India service in future. Preferably, English may be the medium of examination for the All India services, although recruitment may be on a state-wise basis. Increase in emoluments of central employees. As far as possible, emoluments of government employees, central and state, should be uniform throughout the country, making due allowances for local or special conditions. State Public Service Commission, Article 317, should be so amended as to vest in the state itself the power of removing from office the chairman or a member of the State Public Service Commission, subject to inquiry by the High Court. Territory of the state. It should be expressly provided in the Constitution itself that the territorial integrity of a state should not be interfered with in any manner except in accordance with any one of the following three alternatives. 1. The consent of the state concerned should be obtained. 2. The issue should be referred to and decided by a high-level judicial tribunal to be constituted for the purpose, and its decision should be binding on all the parties. 3. The opinion of the people of the area or areas concerned should be ascertained by holding a special poll. Representation of states in Parliament, Council of States. There should be equal representation for each state. That's to say, each state should have the same number of representatives, irrespective of population. There should be no nominations to the Council of States. House of the People. The number of seats fixed for each state in 1951 should remain unaltered except where there is increase in population, in which case the number of seats may be increased subject to a maximum. However, in no case should the number of seats fixed for each state in 1951 be reduced. Language. Members of Parliament should be given the option of addressing the House either in English or in any of the languages specified in the 8th schedule to the Constitution. The link language between the centre and the states and states inter se should be English. English should continue to be the language of the Supreme Court and the High Courts. The offices of the central government situated in any state should use the official language of that state for transaction of business in those offices with the public. All communications by and between central government offices in the state and the government of the state and its offices should be in the official language of the state. Members of the central services employed in a state should be well conversant with the official language of the state. Trade and Commerce, Article 302. This article should be so amended as to omit the reference to interstate trade and commerce. It should be expressly provided that the restrictions which Parliament may impose on interstate trade and commerce should be reasonable. Article 304b, the proviso to this article should be omitted. Public order. The Central Reserve Police Force should not be deployed in any state except at the request or with the consent of that state. Article 355 should be amended accordingly. Machinery for conducting elections to the state legislatures. The delimitation of constituencies made in 1951 should continue. Both the Representation of the People's Act 1950, Central Act 153 of 1950, and the Representation of the People's Act 1951, Central Act 153 of 1951 should be amended so as to confine their provisions and the rules made thereunder to elections to Parliament. The state legislatures must be left free to enact laws in relation to elections to the state legislatures. Interstate water disputes. All disputes relating to interstate rivers should be decided by the Supreme Court, and satisfactory provisions should be made for implementing its decisions. Seabed under territorial waters. Article 297 should be amended so as to vest in the state itself all lands, minerals, and other things of value underlying the ocean within the territorial waters adjacent to that state. Union Executive. Conventions should be established regulating the formation of the Union Cabinet in such a way as to secure, consistent with the parliamentary type of government and all that it involves, representation for the various regions of the country. The number of central ministers of cabinet rank belonging to any one single state should not be more than 1/5 of the total number. Amendment of the Constitution. Every amendment of the Constitution, irrespective of the provision involved, should need ratification by the legislatures of 3/4 or at least 2/3 of the states, representing 3/4 or at least 2/3 of the total population of all states. Signed, P.V. Rajamannar, Chairman; A.L. Mudaliar, Member; P. Chandra Reddy, Member, Madras, 10th of March, 1971.